Hello everybody and welcome to our webinar, Tips for Franchisor Legal Compliance. We hope you find it informative and helps you put in place an action plan to promote your own legal compliance. My name's Emma. I'm the practice group leader of LegalVision's franchising and leasing team. I'm joined today by my lovely colleague Annalise, who's a senior lawyer in our team and very experienced franchise lawyer. Now, before we begin, just a couple of quick housekeeping matters. You will all receive a recording and a copy of these slides in your email at the conclusion of today's webinar. If you have any questions that arise during the webinar, please submit those. There's a chat box at the bottom of your screen and we'll have a Q&A at the end of the session. Finally, we'll be circulating a feedback survey after the completion of today's webinar, and we'd be grateful if you could complete that. Also, all attendees are eligible to receive a free consult with us to discuss how we can help you with your contracts or any of your legal needs. To request your free consult, please provide us with your contact details in the survey that I spoke about just now, and that will appear at the end of the webinar. So today we'll be discussing at a high level some of what we see as the key risks that face franchisors and helping you develop some action points to mitigate those risks. In particular, we'll be looking at firstly unfair contract laws and how they will impact franchise agreements. We'll be looking at the pre-contract representations, in particular claims of misleading and deceptive conduct. We'll be looking at the franchise document update process. We'll be looking at the vulnerable workers obligations that affect franchisors. We'll be considering the issue of marketing fund compliance, obviously a hot topic in the franchise community at the moment and a focus point of the ACCC. We'll be talking through some practical measures that you can implement to protect your valuable intellectual property. We'll be having a quick session on data and privacy and what you can do to ensure legal compliance in those fields. And then, as I said, we'll be having a Q&A at the end. Again, feel free to pop any questions that arise in the chat box at the end. So now I'll hand over to Annalise, who will speak about the UCT laws.
Thanks, Emma. So the unfair contract laws have recently been amended in Australia. As of 9 of November this year, breaches of those laws will now incur penalties of up to $50 million, which is why we're flagging it with all of you guys being franchisors, franchisees in the franchising space. Previously, these unfair contract laws could be deemed void. So if you had these clauses, they'd be struck out, but there was no financial penalty. Generally, a term will be an unfair contract term if it gives one party a significant advantage over the other, things like unilateral rights to terminate, if it's not necessary to protect your legitimate interests, so there's no real reason for you to have that in there, and it would cause financial or other harm to the other party if enforced. Important question for you all to consider is whether your franchise agreement is a standard form contract. This is because unfair contract laws only apply to standard form contracts. Our view, based on what we've seen in this space, is that a franchise agreement is likely a standard form contract. This is just where it's standardized. If negotiations do occur, they're very minor in our experience. Maybe 1 out of every 100 would be more than minor. And even if they are more extensive, where there's no judicial determinations in this area, it's somewhat grey what the court would decide. You know, we're advising clients just err on the side of caution, review their franchise agreements and make sure there's no unfair contract terms in there. The franchise agreements we've seen, there are a few standard terms that would be unfair. Those are things like entire agreement clauses. They're your standard ones that say this agreement captures everything. There's nothing else that supersedes it, those kind of things. Any unilateral termination, which are already flagged, most franchise agreements have something to this effect, maybe not as comprehensive as you'd see in other agreements, but a right for you to unilaterally terminate, and clauses that refer to like documents that aren't incorporated. So things like the operations manual applies, which I'm sure is in most franchise agreements or everyone I've seen. These are considered unfair just where they're trying to incorporate a document that you haven't provided that party, Clearly, it's not fair to try to bind them by that. So we would encourage you all to review your franchise agreements, get a lawyer to review them and see where your risks may lie. Of course, all of your agreements should be reviewed, things like your standard terms and conditions, supply agreements, those kind of things. The main takeaway we do want to kind of drill home after this section is that you should review that franchise agreement, any other standard form contracts, and as a practical tip, it's good to provide any related agreements to the franchisee prior to signing the franchise agreement, just to avoid that classification as an unfair contract term. I'll now pass over to Emma for our next topic about pre-contract representations.
Thank you, Annalise. Now, both in our experience and from what happens in the Australian court system, a lot of the leading franchise cases that have resulted in the franchisor having to pay damages or penalties have arisen because of things that have occurred before the franchise agreement is signed, in what we call the pre-contract phase. In particular, it seems in this phase when franchisees are being recruited, when they're being wined and dined and ultimately sold on the franchise opportunity, this is the perfect breeding ground for incidences of misleading and deceptive conduct. Now, misleading and deceptive conduct is governed by Section 18(1) of the Australian Consumer Law, which simply provides that a person must not, in trade or commerce, engage in conduct that is misleading and deceptive or is likely to mislead or deceive. Very simple statutory definition. So how does that apply in the context of franchising? Perhaps the best way to get an understanding is to look at some actual case law examples. In 2002, a case was determined, that of Lanhigh versus 7-Eleven. Here, it was found that the franchisor had misled the franchisee in making representations in pre-contract exchanges that the term of the franchise would be 10 years. A document that basically summarised the standard franchise offering was provided to the incoming franchisee right at the start of the negotiation. In addition, the franchisor's business development manager made comments that basically echoed what was in that document, namely that the term would be 10 years. Importantly, even though the franchise agreement clearly stated that the term of the franchise agreement would be per the lease, which here was actually 7 years, it was held that the representations made in the pre-contract documents were misleading and amounted to misleading and deceptive conduct. This is an example of a team member's likely off-the-cuff or standard comments coming back to haunt the franchisor. The franchisee was here awarded damages of just under 600 grand. When you take into account that there was no doubt costs orders made and the costs also incurred by 7-Eleven, that franchisor would likely have been out of pocket around $1 million as a consequence of what really could be deemed provision of a standard document and a off-the-cuff statement by a team member. Another recent example is the UFC case, where a group of 3 UFC gym franchisees sued the franchisor for misleading and deceptive conduct and won. The conduct in question here, again, it was all in that pre-contract phase. Firstly, there were general statements made, both verbally and in writing, as to the establishment costs. Secondly, there was a provision of a financial model, if you will, which had data inputted into it that the franchisees were encouraged to use to develop their own business plans. And thirdly, there were some very broad brush statements to the effect that the UFC gyms already operating at that time were profitable. Now, these statements were generally held by the court to be misleading, where the gyms operating at the relevant time weren't actually profitable and where the fit-out costs didn't include key equipment purchases that would be required. The franchisee parties successfully claimed that the statements made by the franchisor were inaccurate and ought to have been known to the franchisor to be inaccurate. Importantly, in this case, the individual directors were also found to be personally liable. Each of the franchise agreements were declared void and damages were awarded in favour of the 3 franchisee parties of around $6 million plus costs. Here, notwithstanding that they had stated in documentation that they were not relying on any franchisor representations, the court was satisfied that they did rely on all of the representations that were conveyed and which I summarised just moments ago. So importantly, even if you have those clauses saying this is the entire agreement, even if you have clauses that say I'm not relying on any external warranty made by the franchisor, it's a matter of fact that will be determined by a court as to whether there was actually reliance, in fact, on representations made. Now, I act in a lot of franchise disputes, and I'd estimate of those that come across my desk, around 75% have elements of misleading and deceptive conduct, usually arising in that pre-contract phase. So it's important. So the importance of having a proactive plan to reduce the likelihood of such a claim emerging for franchisors cannot be underestimated. So what can franchisors do to mitigate this risk? We've recently prepared a health check document for franchisors, which sets a lot of this out, and we can provide to all our attendees after the webinar. But some of the steps that we've included on this risk item are to ensure all of your promotional advertisements, sales team communications, and franchise brochures have been reviewed for accuracy, and any risky or misleading statements have been removed. Require your incoming franchisees to get legal advice. Don't just suggest it. Ensure any financial models and estimated franchisee revenue are based on actual historical data with appropriate legal disclaimers. Ensure your staff are trained on key legal risks from franchisees, including what can amount to misleading and deceptive conduct. And always remember that throwaway comments can come back to haunt you. I'll hand over to Annalise for franchise document update discussions.
Yes, so in line with pre-representations, your disclosure documents. So every year as a franchisor, you'd have to update your disclosure document and your key fact sheet. It has to be done by end of October at the latest. You now also as a franchisor have to register on the franchise disclosure register at the same time. We have noticed this is something that franchisors are still letting slip through the cracks, so definitely something to put at the top of your list. As part of this annual update, the main thing is updating that disclosure document. The main part of that we find holds up this process is your financial disclosure. As a franchisor, you have to provide either the last 2 years' financial reports or an independent audit report, which has to be updated yearly. Now, where this obviously requires a third party, being your accountant or an auditor, to help prepare these documents, we do find it can delay the finalising. It is particularly important that you take these steps now, particularly where those super penalties that came into play last year, where you can incur penalties of up to $10 million per contravention, actually apply to this section. So if something were to eventuate and someone were to bring a claim that you didn't comply and didn't provide up-to-date financial disclosure documents, that super penalty would apply, which is not something anyone wants to deal with. In the standard update and the body of the document, it can be a bit overwhelming, I'm sure. The main parts we pick out and think are really important for franchisors to really go over with a fine-tooth comb are the costs you're disclosing in the disclosure document, being those costs to run the business. Particularly in light of recent inflation, I'm sure every franchisor will really need to update these costs to reflect what things are actually costing now. It's a lot more than last year, I can say from personal experience. It's really important where this is another pre-contractual document. Franchisees often rely on this. If it's not accurate, it's likely to mislead them. We do recommend that to ensure these are accurate, your accountant reviews these costs, cross-check them with your actual bookkeeping data. Where you have a large network, you should have a lot of data to ensure that these are accurate. And just do everything you can to keep them as up-to-date as possible. Another key area that has to be updated every year and can be left to the last minute are your annual rebates and financial benefits. If you're receiving these as a franchisor, we suggest you ask your accountant now to put together info regarding the financial benefits you are receiving, any rebates from suppliers, approved suppliers, those kind of arrangements, just so you have this ready early. The reason we're kind of drilling home about this is, in addition to those super penalties for that financial disclosure, there are also an increase of the maximum penalties under the code in general. So any breach of the code is now $166K per breach. which can amount to a lot of money. So it's important that you are taking active steps to provide an up-to-date document, registering on the disclosure register, providing the key fact sheet, and making sure everything reflects the actual status of your network. In addition, and I've kind of drilled home in this section, is as touched on by Emma in the recent UFC decision, if there is incorrect financial data, it's been proven now that the court may show that they can amount to misleading or deceptive conduct. It can be a misrepresentation and ultimately can cost you not only financially, but the reputation of your brand as a whole. Another area of law that can affect that reputation is, your vulnerable workers obligations, and Emma will now take us through those.
Thank you. Vulnerable workers obligations. As Annalise mentioned, it's been subject of a lot of media attention of late, and it should be on every franchisor's radar. The relevant statutory provisions, referred to generally as the vulnerable workers provisions, were introduced by the Fair Work Amendment Act in 2017. These provisions introduced franchisor liability where the franchisor knew or could reasonably be expected to know of a franchisee's breach of workplace laws. But the Act limits the franchisor's exposure to liability if at the time of the relevant contravention, the franchisor had taken reasonable steps to prevent the contravention. Bit of a mouthful of a legal test, but the key takeaway there for franchisors is those two words, reasonable steps. Recently, the Fair Work Ombudsman has initiated proceedings against the franchisor of the 85 Degrees franchise network in relation to breaches of the Vulnerable Workers Act, where some of its franchisees have breached the Fair Work Act by underpaying some of its team members and not providing pay slips. Here, the Fair Work Ombudsman has claimed that the franchisor failed to take those reasonable steps to prevent the contravention, and has claimed that the franchisor should, in the circumstances, have known some of its franchisees would underpay their workers and breach record keeping laws. That franchisor faces penalties of up to $63,000 per breach, so the total could well be in the six figures. Of course, even if the franchisor is not sued, having a franchisee deemed to have breached workplace laws can have serious ramifications for a franchise brand. Subway, McDonald's, Caltex, 7-Eleven, all big franchisor brands who have faced underpayment scandals in recent years and obtained a huge amount of negative publicity as a result. So, what are these reasonable steps that all franchisors should be taking? Some of the practical steps that we recommend include having a section in your operations manuals which identify key workplace policies, laws, and guidelines. You should also revisit those sections whenever there is a change in workplace laws, and in particular annually after an award rate increase. The franchisor should undertake regular employment legal compliance audits across the franchise network, and not just when there's been a complaint or an issue raised, but randomly a couple of times per year or more, depending on the size of your network. The franchisor should have an internal complaint handling procedure for franchisee employees that's actually accessible and which results in action being taken. One thing I've seen is franchisors requiring, by way of their manuals, all employees being onboarded to be provided with a notice that has the contact details of a franchisor representative who they can contact if they have any employment law related issues at all. Franchisee training should be conducted on workplace best practice and the workplace laws that apply to them. Now, this should occur both at the start of the franchise relationship when the initial training is provided, but also on an ongoing basis. Again, particularly where there is an update in laws. Right now, for example, we've recently seen the updated superannuation guarantee percentage, and this is something every franchisor should have informed every franchisee about. I'll hand over to Annalise, who's going to talk us through marketing fund compliance.
Yes, so marketing funds, one that the ACCC has, again, publicised will be a focus area. As a franchisor, if you're operating a marketing fund, you really need to take this issue seriously and actively take steps now to ensure compliance. You may be asking, what is a marketing fund? Essentially, it's just a pool of money that franchisees pay into. If you're a franchisor, you operate corporate stores, you also need to pay into that fund. It's generally managed by a franchisor or related entity, something similar to that. If you operate one, there are additional obligations under the code, and these fall in line with your annual disclosure document obligations as well. The really important thing if you operate a marketing fund is you can only pay money out of that fund if it's been for purposes that have been disclosed to the franchisee, and that can be in your disclosure document, agreed to by a majority of franchisees. So that can be by way of, or questionnaires, that kind of thing, taking a vote, or that purely relate to marketing. In our experience, this is an area that the ACCC is paying more attention to. It's clear through, the cases that have come before the court. So it's really important you pay attention to what actually is a marketing fund. One of the most common issues that we see arise is where a franchisor is paying for an employee's salary out of the marketing fund, where that employee is not purely engaged in a marketing role. You might have an employee who's in an administrative role and might be spending 50% of their time marketing and the other doing other administrative tasks. If you're making payment of all of their salary out of the fund, these will likely not be marketing expenses and you could be in breach of the code. As part of our legal health check, which is available in the handout panel for download, so everyone who's online can download it even now, I believe, we review not only your marketing fund report, which sets out all the money you're spending out of the marketing fund, but each item and whether in our view they are actually marketing expenses. It is common in the marketing funds we see for large group of items to just be grouped together and they might not actually be marketing functions. An example I've seen a bit over the past kind of couple of years with Uber and the emergence of everyone ordering online is third-party delivery applications and any price updates on those platforms being contributed to marketing expenses. If these updates on the third-party delivery platform aren't actually for a promotion or some kind of marketing function, but are more so just a standard price update across the network, it may be that it isn't a marketing expense and you shouldn't be charging that out of the fund. There is another big area that has been around media attention in the marketing fund, which is sufficient detail. So this marketing fund report that we are talking about has to contain sufficient detail. What does that mean? For a long time we didn't know. And in 2019, there was the Ultratune case, which I'm sure a lot of you have heard of. The court found that this sufficient detail and this meaningful information hadn't been provided to franchisees. The court basically took the stance of franchisors should err on the side of caution, be as transparent and honest as possible in disclosing the fees and what they're being spent for out of these funds. In this case, one of the key examples was Ultratune were running TV advertisements and they hadn't set out where the ads were being aired. The takeaway from that really is a franchisee should be able to look at your marketing fund report, see where this marketing is being spent, and actually have an idea of whether it's helping them, it's in their area, how that marketing may be contributing to their business. As I said before, one of the important things is not putting in broad catch-alls. That obviously isn't going to provide them sufficient detail as to how it's helping them. Most franchisors would spend money on AdWords. Just putting in AdWords isn't going to be sufficient in our view. You should be setting out details of, for example, the AdWords that were purchased. If you're purchasing hundreds of thousands, not every single one, but those key ones we would advise our clients definitely do. Practical steps for this, where it is quite a big obligation on an ongoing basis to make it a less of an administrative burden at the end of the year. You should be keeping accurate and up-to-date records, setting out marketing expenses and the exact activity attributed to the expense. People working in marketing should be helping you with this on an ongoing basis. You should be reviewing your marketing fund every year, having a lawyer look at it as well, and just ensuring that clear detail is provided, going at it with the look of, could a franchisee look at this and see where this money is actually going? on marketing, and a somewhat related issue is intellectual property, and Emma will take us through the key risks of IP as a franchisor.
Thank you, Annalise. Nice tie-in. So IP, intellectual property, it's the heart of every franchise network. It's your brand, it's your get-up, it's your name, it's your systems, and it's what makes you unique. Despite this, we see a lot of franchisors that don't have in place adequate IP protection. As a franchisor, there are many practical steps that you can take to ensure that your IP is properly protected. Firstly, you should always be mindful of your corporate structure and consider a restructure where it is appropriate, particularly when your franchise network gets to a certain size. We recommend that your IP be quarantined, if you will, in a separate IP company so that it's not vulnerable to any wind-up, insolvency, or any franchisee claims. You should also, of course, ensure that all of your IP that should be registered is registered. In particular, that your trademarks are registered, both your logo and your name, and that they're registered in every category in which you intend to operate. This is a vital step in protecting your brand nationwide. Similarly, if you have global expansion plans and you're looking at going into another jurisdiction, the first thing you should do is register your marks in that jurisdiction. To protect your IP, you should also have appropriate clauses in your franchise agreement. You should have clauses in your franchise agreement that really clearly define what is the intellectual property. And we often go to the extent of naming certain key documents or key registers. Similarly, customer databases and customer information is often a key point for contention. To the extent that a franchisor wishes to claim that as their intellectual property, which is the most common thing in Australia, the customer database, customer information should clearly be set out in your definition of IP, which is adopted in the appropriate operative terms of your franchise agreement. There should be clauses which clearly set out that the franchisee is only entitled to exploit the IP in connection with the franchise network. There should be clauses whereby the franchisees have to notify the franchisor of any actual or threatened breach of the franchisor's IP rights. And you should make sure that access to IP is limited in certain ways by having, for example, read-only access where a franchisee might not have to edit certain IP, by having provisions whereby a franchisee is not entitled to make copies of certain critical IP, and in particular, client databases. Thirdly, where you have in place a holding entity or an IP entity, you need to ensure that there's a proper right of use that's been granted to your franchising entity or your main franchise entity. Typically, this is done by an IP assignment and license deed, which is then reflected in the terms of your disclosure document. So making sure you have those proper permissions in place is another important aspect of IP protection. So I'll just hand over to Annalise to quickly touch on data and privacy, hot topics at the moment.
Yes, so something you probably don't hear come up when you talk about franchising a lot is data and privacy. But there is no doubt that it is a hot topic as of late. Large corporate brands like Optus and Medibank have had data leaks. There are also changes to the penalties available under the Privacy Act, which sets out these privacy obligations. It includes an increase in penalties. So currently, penalties for a breach of the Privacy Act are $2.5 million per contravention. That will likely be going up to $50 million per contravention, which is a very significant jump. An important takeaway is that the Privacy Act only applies to what is referred to as APP entities. In general, you will be an APP entity if you have an annual turnover of more than $3 million, provide healthcare services, enter into government contracts, or trade in government contracts. Even if you're not an APP entity, it is best practice that you do comply with the Privacy Act. Customers have actually come to expect it, is our experience in the market, and we do advise that all of our clients comply regardless. In franchises where that personal information is often being shared between you as a franchisor and franchisees, it is vital that you put in appropriate policies and procedures, including through the operations manual, to make sure all parties are across how this data should be dealt with. as a franchisor, practical tips to comply with your privacy obligations are to ensure you have a privacy policy in place, which basically sets out how you'll deal with private information, and information collection notice as well, and these documents should be available to franchisees as well. You should also ensure you have data management processes and governance measures in place internally. So that's really how you're going to deal with this data internally, so you have employees all on the same page. You should be providing training to franchisees in relation to privacy obligations as part of both that initial and ongoing training and how this can be collected. And you should have a lawyer review your privacy policy. It's often posted on your website just to make sure it is compliant. And if franchisees are having their own privacy policy, making sure that you audit their policies as well to make sure they're also compliant with their obligations. That now concludes the main part of our webinar. Most of the topics we went through today are covered in our franchise legal health checklist, which you can download in the handout panel. There's the QR code there. We go through kind of the more practical steps we concluded at the end and some things you should put into place. We also have an upcoming event that may be of interest to you on expanding your franchise network, best practices for recruiting top franchises. It'll be on Thursday, 24 August, 11 a.m. So if you're interested, you can register now, follow us on LinkedIn or whatever to get some updates as to when that's coming up. We're going to answer your questions shortly. While you submit them, we'll just take a minute to go through how we at LegalVision work. So at LegalVision, we offer all of our services through a membership, including for our franchisors. We found it's a more inexpensive way to service our clients end to end, rather than you as a franchisor incurring hourly rates for every single question you have, which in our experience with franchisors is significant. The membership model just provides cost certainty, and that's the real positive. It includes all your business as normal needs. So your franchise document updates that we spoke through today, the marketing fund review. We do these kind of legal health checklists for our franchisor clients, all as part of the membership. Unlimited consults with us, but also unlimited consults with our team, which grows every day. Employment team, trademarks team, corporate team, who can really give you specialised advice hand in hand with our team who are knowledgeable about the franchising aspects of those areas on anything you need. Really, at any day, you can book in a call. We like to think of it as your in-house counsel, but with many lawyers who are specialised in their own areas. If you do want to learn more about our membership, you can request a free consult when the survey appears at the end of this webinar. Of course, you can also go on our website and request a consult later. Whatever you like, we'd love to help you guys out. We'll now answer some of the questions that we have received.
Thank you. Guys, again, any questions, pop them in the box below. We've had a couple submitted. Firstly, are there any exclusions to the disclosure requirements for very small franchises? Yes, there are. So typically franchisors are required to update their disclosure document and key fact sheet by the end of October each year. One exception to that is a franchisor that has not taken on any new franchisees in the past financial year or does not plan to take on any new franchisees in the next financial year. But either of those two exceptions apply. It's important to be aware, though, that an existing franchisee is nevertheless entitled to request a copy of the updated and current disclosure document from a franchisor, which you have to provide within 14 days, meaning you could be scrambling to put that together. Another question, how do you determine an inaccurate financial model at the pre-contract stage? So this obviously relates to the discussion that we had on misleading and deceptive conduct. I don't want to get too in depth, but typically there are two types of misleading and deceptive conduct or misrepresentations. Misrepresentations as to current matters, which can be determined inaccurate by the accuracy at the time. If I say I'm making $500 per week, but in actuality, my data shows that I'm only making $300 per week, that's an inaccurate financial statement. The perhaps more contentious one is statements as to future matters. Here, the test that it's applied by the court is, did the franchisor or the party making the statement have a reasonable basis to make that statement? In assessing that reasonable basis, they will look at the financial and other material that was available to the franchisor at the time. Here, for example, turning back to the UFC case, saying that all of the current franchisees are profitable, and therefore you will be profitable. The second part is a statement as to future matter, but it's inaccurate where there was no reasonable basis to make the statement because the data at the time showed the trading franchisees were not actually profitable. Similarly, if you say, oh, you can expect to have 1,000 members sign up within 3 months, but your data shows that really the existing franchisees are only getting 100 customers signing on per month on average, there's no reasonable basis to make that statement. I hope that answers that question. Any other questions, guys? There's just one coming through. Do you want to take this one, Annalise? It's a marketing fund one.
Yes, the question is, what if a franchisor is spending marketing funds only in Sydney and not in northern New South Wales, which doesn't benefit your store in any way at all? What can I do? I presume you are a franchisee. This is a bit of a nuanced question, and it does come down to whether they have disclosed the purposes of the marketing fund expenses that they're paying out of that marketing fund are all ones that have either been disclosed to you or approved by you. As a more difficult or grey area to argue is that you could definitely raise with the franchisor the fact that there is no marketing being spent in your area. And I've definitely seen individuals raise this with the franchisor, and it can be advanced. You do need to have kind of a legal review of the documents that have been provided to you, what they have said the marketing will be spent on, the spread of franchisees. If you're in quite a large network and say 95% of them are in Sydney, it may be a little bit more difficult to advance an argument that they should be spending more of the fund in your area. And it also is a question of not benefiting your store at all in any way. It does depend, obviously, that is probably how it may not be benefiting your store at all, but that may not be due to the franchisor's marketing efforts per se. It may just be, the clientele don't respond to that kind of marketing or whatever the case may be. It's definitely something you should be getting advice on, though, if you do feel that the marketing you're contributing to is not benefiting you at all. We would encourage you to provide those documents, being your franchise agreement, disclosure document, and any correspondence with the franchisor you've already had about how you feel the marketing isn't helping you as a franchisee be successful. And then that can be explored as to whether there is either a breach there or whether it's just not in good faith and the franchisor isn't acting in your best interests in that relationship. Did you have anything to add, Emma?
Nope, I think that covered it. It's a tricky one, marketing fund expenditure, where a franchisor is entitled to exercise some discretion. And typically there's a clause in the franchise agreement that allows them to exercise that discretion. Just got another question coming through. If an employee from a franchisee reports that they're underpaid, what can the franchisor do? Can the franchisor advise the employee to report to Fair Work or the ATO? Well, yes, they can, but perhaps more importantly, a franchisor will typically have a clause in their franchise agreement that requires the franchisee to comply with all laws. Those laws would capture, of course, the Fair Work Act and any relevant award that applies to this particular franchisee. A franchisor can be proactive in issuing a breach notice, requiring the underpayment to be rectified and proceeding to terminate if the breach notice is not rectified or remedied in the manner set out. Franchisor should firstly, of course, be undertaking an audit to ensure that the allegation of underpayment is actually correct. I think that's it, unless we have any final questions, guys. Doesn't look like there's any more coming through. Oh, no more questions. Perfect. So thank you all for attending today. We hope you found it useful. Again, a copy of our franchise health check document is something that we've referred to and relied on in preparing for this webinar. A survey will pop up when the webinar is ended, and we would be appreciative if you could complete that 30-second survey. And of course, if you do want to have a consult with one of our experienced franchise lawyers, then pop your contact details in that survey. Thanks so much. Have a great day, guys.
Thanks. Bye.